Ready, start. This batch of writ petitions could be jointly disposed of, especially taking note of the stand taken by the Insurance Regulatory and Development Authority, the Tariff Advisory Committee (General Insurance) and the four insurance companies in the public sector, viz. New India Assurance Company Limited, National Insurance Company Limited, Oriental Insurance Company Limited, and the United Insurance Company Limited OP number 31646 of 2002 is taken as the leading case since pleadings are complete. The parties above referred to are respectively respondents 1 to 6 in the said writ petition. The counsel representing the petitioner in the other original petitions were also heard, and the positions explained were acceptable to them. Apparently, this is because the first and second respondents had risen to the occasion, understanding the appreciating the grievances that were voiced in the batch of cases and bound by the edicts issued by them, and insurance were disabled to strike discordant notes, though they would have very much wished to have freedom for negotiation. This is because under Section 64 UC of the Insurance Act, the Advisory Committee, statutorily recognized, has been vested with the power for fixing, amending, or modifying any rates, advantage, terms, or conditions relating to any risk, and the decisions are given fully. A breach would have led to a presumption that the insurer would have to contravene the provisions of the Act. Para. The issue agitated was about the demand and instances for increased tariff pertaining to third party premium in respect of the vehicles and especially commercial vehicles. Petitioners submit that the premium payable in respect of the different classes of vehicles are statutorily fixed by the Tariff Advisory Committee hereinafter referred to as TAC Act by Exhibit P1 in a comprehensive manner. They had laid down rules, regulation, rates, advantages, terms and conditions for transaction of motor insurance in consonance with Part 2B of the Insurance Act 1938. The tariff superseded superseded the one existing as on 36 2002. Rationalization was brought about by order dated 25/4 2002 and on 7/4 2002. The chairman TAC clarified the methodology for loading in bracket added increase of the rates bracket close as following. It is now clarified that insurance may load the third party tariff motor premium by 100% if the claim experience of any individual owner is adverse per the as per the insurance assessment. If the experience continues to be bad, then a further loading of 100% on the expiring premium can be charged. Insurance may not load the premium further. This order issues under Section 64 UC of the Insurance Act 1938. Thus, the increase was only to be on the basis of individual cases noticing their track record, but overlooking the binding orders. Certain instructions came to be passed by the state owned companies in effect permitting their officers to load much more than permissible limits. The TAC had therefore issued further instructions by circular dated 28/5/2002, positively holding that loading was to be done only within permissible limits on the claim experience of particular individual fleet owner and not on a universal basis. By Exhibit P4, the regulatory authority also had come to the scene, as it had been found that the insurance were attempting to have filed days. Most of the cases came to be filed in the above period. The companies were instructed to issue circulars to all operating officers for the purpose of general instruction and for avoiding complaints, but this was not being dutifully followed.